Hello friends, very warm welcome to my business law channel. Today friends, in this video I'm going to discuss the question paper of BCom Honors which was held in the month of March-April 2022. Now this will be useful for BCom program second semester also because syllabus is the same. So let us begin now. Friends, you all know paper is of 75 marks. In OBE, there are 6 questions. And out of 6, students are asked to attempt any 4 questions. Let us begin now. The very first question is before you, which is, friends, apart from minority and unsoundness of mind, the capacity to contract of a person may be affected by virtue of any special law to which he is subject. Comment on the statement. So friends, in this question, what we have to write? We have to write about minority. And then unsoundness of mind. And then the last heading will be, friends, persons disqualified by law to which they are subject. So you all know, friends, capacity of the parties to contract has been defined under section 11 of ICA 1872. Minor person, then person of unsound mind, and person who has been declared as disqualified under the law to which he is subject. So all these points you have to discuss in this. So minority, you all know, friends, minor is very important. Any person who has not attained the age of 18 years is a minor. And minor is the privileged person in the eyes of law. He has been given number of privileges under ICA 1872. It's a rule of estoppel. All agreements which are entered into with a minor are absolutely void and inoperative as against him. And there is a very important case law, which is Mohiri Bibi versus Dharmodas Ghosh. Person of unsound mind has been defined under section 12. So friends, regarding minor, you will have to write all important points. Rule of ratification, minor can always plead minority, minor's liability in torts, minor liability in necessities. All these important points you have to write. Then unsoundness of mind, it has been provided under section 12. Person may be usually of sound mind and occasionally of unsound mind, or usually of unsound mind and occasionally of sound mind. So friends, unsound mind person is also treated on the same footing as that of minor. Unsoundness of the mind may arise from 5 reasons: idiocy, lunacy, drunkenness or intoxication, hypnotism, and mental decay on account of old age. And then disqualified persons. There are 7 points under this. Alien friend can contract, but alien enemy cannot. Insolvent person. Then, foreign ambassadors. And then joint stock company. Okay, so convict person, married woman. So all these are the persons who have been put under the category of disqualified persons. You have to write all the provisions regarding them in detail. Now coming to the second question, friends, which is regarding case law. Case study. The delivery boy of pizzeria delivered a pizza to the wrong address to one Mr. Ravi. He had neither ordered nor paid for it, either in advance or in cash. Mr. Ravi keeps the pizza, considering it as a part of promotion campaign of the company. Is Mr. Ravi bound to pay to the true owner who paid for it or to pizzeria? What are the provisions of restitution mandated under the quasi-contract under Indian Contract Act 1872? So friends, in this question, second question, the practical problem or case study is of 8.75 marks. And then second part of the question where you have to write all the types of quasi-contracts. There are 5 types of quasi-contracts which you have to write. So let me answer the first case study And then I will come to the second part of the question. So regarding this case study, you will have to mention the point goods delivered, goods or money delivered under coercion or by mistake, section 72. So here, the goods have been delivered to Ravi by mistake. And he never paid for it, but he consumed pizza. He enjoyed pizza. Then it becomes his duty. If he has enjoyed the item which he has received by mistake, then it becomes his duty. He must pay for that. So the principle of restitution applies. Then he will have to make the payment to pizzeria or to the owner who has given the order. And coming to the second part of the question, friends, which is about other quasi-contracts, you all know there are 5 types of quasi-contracts which have been provided under section 68 to 72 of ICA 1872. No necessity is supplied to the incapable person or person who is dependent upon him. Then payment made by interested person. Non-gratuitous act, responsibility of finder of goods, goods delivered under coercion or money paid by mistake, or the goods delivered under mistake. So friends, all these points you will have to explain with the help of examples or requirements. Then coming to the third question is Bailey enjoys certain rights under the bailor and the goods. Against the bailor and the goods. Elucidate, explain the nature of the bailey's particular lien. How does it differ from general lien of bankers and factors? Now, bailey enjoys certain rights. Of course, friends, bailey enjoys certain rights against the bailor. Duties of bailor are the rights of bailey. So, friends, for this, you can refer to my video on bailment, okay? And there, I have written the rights of and duties of bailor and bailey. So, those points you can include under this, and you have to explain with examples. Then, what is particular lien? Lien can be of 2 types. One is particular lien, and second is general lien. Particular lien is exercised against particular goods only, or particular property only, in respect of which certain labor has been expended. But general lien is always exercised for general balance of account. So there are mainly 3 to 4 points of distinction between the general and particular lien. Always write the distinction in the tabular form. Meaning is different, then purpose is also different, and different parties are entitled to each type of lien, general lien and particular lien. Okay. So friends, all these answers you will have to write. Coming to the next question, question number 4, which is who is considered as an unpaid seller and what are his rights under the Sale of Goods Act 1930. Also explain the rights with respect to the following case. Who is considered as an unpaid seller? This question's answer is of 2 marks. Unpaid seller has been defined under section 45. Any seller who has not been paid or tendered part or whole of the price, or who has been given bill of exchange or any other negotiable instrument as a conditional payment which has been subsequently dishonored. So this is the meaning of unpaid seller. And then friends, unpaid seller has certain rights against the goods. When the ownership has passed, when the ownership has not passed. When the ownership has passed, he has got 3 rights. Right of lien, right of stoppage of goods in transit, and right of resale. And then when the ownership has not passed, he has 1 right only, which is right to withhold the delivery of goods. So friends, for all these answers, you can refer my video under the Sale of Goods Act. Go to the playlist, okay? And then, all chapters relating to the Sale of Goods Act, you will find there. Now coming to the case study here under question number 4, which is Rajan sells to Mahesh a quantity of cotton lying in Rajan's warehouse, giving a 3 months credit to Mahesh. Mahesh allows the cotton to remain in Rajan's warehouse. Before the expiry of 3 months, Mahesh becomes insolvent. So Rajan is the seller and Mahesh is the buyer. Okay. Now the credit period is 3 months. Mahesh has become insolvent. And the official assignee demands delivery of the cotton from Rajan without offering to pay the price. So as friends, Mahesh has become insolvent. So it means he won't be able to pay the whole price, whatever rateable dividend he can pay. So official assignee of Mahesh will have to pay that amount to the seller Rajan, and Rajan will have to give the delivery of goods to the official receiver or assignee of Mahesh. Okay. And now, we can also say that is Rajan entitled to retain the goods until paid? Rajan has a right to retain the goods, which is known as the right of claim, because the goods are in his possession, in the possession of seller. Wherever the goods are in the possession of seller, then the seller has the right to retain the goods. So friends, he has the right to retain the goods till he is paid, but Mahesh, official receiver, he won't be able to pay the entire price. Whatever rateable dividend he can pay, he will pay, and he will get the possession of goods from the seller, Rajan. Moving ahead, friends, question number 5. Question number 5 is discuss the legal effect of incorporation or registration of a limited liability partnership. State the procedure to be followed for effecting the change of registered office from one state to another state as per the Limited Liability Partnership Rules 2009. So friends, what are the consequences of incorporation or registration? They have been provided under section 14. 3, 4 to 4 points are there. So when all the steps relating to the incorporation they are followed, then the LLP becomes the separate legal entity. Being the separate legal entity, it can hold assets, dispose of assets, and enjoy assets, all assets, movable, immovable, tangible, intangible, okay, as a going concern. And it may have the common seal. It is not must that LLP should have the common seal. It may have the common seal if the partners of the LLP so desire. So these are the consequences of incorporation or registration of LLP, which have been provided under section 14. State the procedure to be followed for effecting the change of registered office from one state to another state. So friends, one place to another within the same state and from one state to another state. Then for this, advertisement, creditor's consent is also must. Advertisement has to be given in the newspaper at least 21 days before. And then, so that 21 days before in that state, from where the registered office is to be shifted. Okay, so this should be given in the English language as well as one language of that particular state. So when all formalities are fulfilled, then the registered office can be shifted from one state to another. Then coming to the next question, the last question, which is question number 6, the two principal hurdles which stand in the way of facilitating electronic commerce and electronic governance are the requirements as to writing and signature for legal recognition. Friends, e-commerce and e-governance, they have given rise to information technology 2000. E-commerce and e-governance. E-governance is smart governance. And there are a number of provisions which have been provided under ITI 2000 which strengthen electronic governance. So e-governance is smart governance. In the light of this statement, explain the terms e-commerce and e-governance. Also describe how digital signatures uses. Digital signature always identifies the originator. Digital signature always, tells about the authenticity of the e-document. And the sender cannot deny from the fact that document was not sent by him. And there is difference between digital signature and electronic signature. Digital signature, electronic signature is a term which was introduced or inserted under the ITAA 2008. There are 6 points of distinction. You can refer to my video regarding IT Act, where you will find 6 differences in the tabular form. So friends, now I would like to conclude. I've explained all the answers for all these questions, the question paper held in the month of March 2022. If you have any doubt, friends, you can always write in the comment section and I will always reply. So all students, regular students or students of SOL or Ncweb, they can go through my videos. They're very important for them and they will all be useful for them. This is all from my side. Do subscribe to my channel if you have not subscribed yet. And I would like to thank all the viewers who have been viewing my videos. Keep smiling and stay healthy always. Okay, friends, we will meet soon. Goodbye.